Jacob Sanchez, if you can stand up, Jacob. And the other is Jackson Sanchez. These are also my nephews. And in the middle there is my sister Jana. Thank you.
Well, great. And welcome to Senate Judiciary Committee and welcome to the Capitol. Hope you have a great day today. Thanks for joining us. Committee, I want to, we do have maybe a couple of bills to work, so I want to make sure we reserve time for that. But I do know we have conferees waiting to speak today, so want to go ahead and open the informational briefing on Senate Bill 9. And before we hear from the reviser, the reason we're having an informational briefing and not a hearing is Senate Bill 9 is not referred to this committee. It is in conference committee, though, with the chair, the vice chair, and the ranking minority member of this committee, but I thought it would be very helpful and instructive for our committee to hear kind of what the issues are in this bill as it moves and is in conference committee. So with that, we'll hear from the reviser.
Thank you, Madam Chair. Senate Bill 9 prohibits foreign principals from acquiring interest in real estate that is close to military installations, and it also prohibits state agencies and local governments from purchasing drones or critical components of drones from foreign principals or those that are manufactured in countries of concern. Section 1 names Section 1 through 8 as the Kansas Land and Military Installation Protection Act. It also provides a purpose statement for the act. Section 2 provides for definitions throughout the act. I would draw your attention probably to the list of the countries of concern on page 2, and then probably the definitions of foreign entity and foreign principal on page 3 would be the definitely ones to review there. Section 3 provides that generally no foreign principal shall directly or indirectly acquire any interest in real property that's located within 100 miles of the boundary of any military installation that's either located in this state or an adjacent state, except for a de minimis interest in that real property. A foreign principal that owns any interest in that type of property shall file registration of that interest with the Attorney General not later than 90 days after the effective date of this act, or whenever the real property was acquired, whichever is later. The bill also lists what that filing to the Attorney General is required to include. The Secretary of State shall provide notice of the registration requirement to all business entities and nonprofit organizations when they register or submit a filing with the Secretary of State. The Attorney General shall provide the Secretary of State with instructions for meeting that filing requirement, and then the Secretary of State has to pass that on to the business entities. A foreign principal that fails to file or acquires interest in real property has to divest that interest in property. A copy of documentation evidencing that divestiture shall be submitted to the Attorney General within 30 days. A foreign principal that owns any interest in that type of property prior to July 1st, 2025, and fails to file shall receive a warning from the Attorney General advising them of the filing requirement. That foreign principal shall be allowed 30 days from the date of receipt of that warning to either file or divest their interest in the property. A foreign principal would be allowed to acquire an interest in real property by devise or bequest through the enforcement of any security interest or through the collection of debt, and that acquisition would be subject to that filing requirement in subsection B. Section 4 requires the Attorney General to investigate suspected violations of the Act. A foreign principal would be allowed to enter into an agreement with the Attorney General to divest their interest in real property not more than 360 days from entering into that agreement. The Attorney General may commence an action to enforce the Act. In such an action, the Attorney General would be able to seek a court order directing divestment in the property, injunctive relief, civil forfeiture of the property, and reasonable attorney fees. Upon a determination by the court that a defendant violated the act, then the defendant would have to divest their interest in the property within 180 days. Section 5 prohibits foreign principals from receiving direct benefits related to any economic development program, regardless of the form of that benefit. Section 6 requires the Attorney General to establish policies and procedures for reporting information concerning non-notified transactions. They're also required to make certain reports to the Committee on Foreign Investment in the United States. They have to submit copies of that report to the governor, the adjutant general, and the standing committees on federal and state affairs. They also have to submit a report to the governor, the adjutant general, the standing committees on commerce in both chambers, and the standing committees on federal and state affairs in both chambers that details the implementation of this act and any recommendations for amendments or changes. Section 7 provides that only upon any occasion when an organization is designated as a foreign terrorist organization under federal law, the Fusion Center Oversight Board may adopt rules and regulations to reflect that designation after giving due consideration to security risks and economic costs and benefits. Section 8 requires Kansas State University on or before March 1st of each year to use their available data and resources to prepare and submit a report to the legislature and the AG detailing the status and trends of all foreign land holdings of real property within Kansas. And then Section 9 provides a severability provision for Sections 1 through 8. Section 10 amends KSA 604104. This is the statute that provides the conduct giving rise to forfeiture under the Kansas Standard Asset Seizure and Forfeiture Act. This amendment would include violation of the Kansas Land and Military Installation Protection Act as conduct that would give rise to asset forfeiture. Section 11 amends KSA 604106. This is the statute with the exemptions to the Forfeiture Act. Current law there requires that conduct has to constitute a felony to be able to forfeit real property. And this bill adds an exception in that exemption for a violation of the Kansas Land and Military Installation Act. So even though that doesn't constitute a felony, that land would be able to be forfeited. Sections 12 and 13 are the drone provisions. Section 12 prohibits a governmental agency from purchasing or acquiring drones or related services, maintenance agreement, or equipment if the critical components are produced in a country of concern or produced or owned by any foreign principal. Any such equipment that was acquired prior to July 1st of 2025 can still be used, but when the agency has to replace that equipment, they would be required to comply with subsection A. An acquisition that would otherwise be prohibited would be able to be completed if there's no other reasonable means to acquire those components or address the needs of the governmental agency. The agreement for that acquisition is approved by the Secretary of Administration after consultation with the Adjutant General. In failure to acquire those components or otherwise address the needs of that agency would pose a greater threat to safety and security of this state than are posed by entering into those agreements to make those acquisitions. This section would apply prospective only. And Section 13 provides definitions for terms that are used in Section 12. Again, I would draw your attention to that list of the countries of concern and the definition of the foreign entities and principles. And I can take any questions.
Thank you. That was a lot to cover. Appreciate that. Committee, any questions for the reviser? Well, then you did a fabulous job. Appreciate it. With that, then, we will invite the first conferee, Jacqueline Deal, with the State Armor Advisory Board. Please introduce yourself and welcome to committee. And, you know, we've got a number of people who want to testify today on a couple of things, so we're going to limit everybody to 4 minutes. And when there's a minute remaining, I will hold up a manila folder to indicate you've got 1 minute remaining to wrap up your thoughts and comments. So with that, Jacqueline Deal, please introduce yourself and welcome to committee. So we have her scheduled to appear via WebEx, so we'll circle back at a later time. And next, then, we'll invite Michael Lucci, Chief Executive Officer, State Armor, also on WebEx. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Am I coming through?
You are, yes.
Excellent. My name is Michael Lucci. I founded State Armor, and the purpose of State Armor is to work with state policymakers on state policy solutions to national security threats. I think that SB 9 speaks really directly to some of those clear threats. First, on the land provision, I'll describe kind of the context of a road perhaps to conflict that's occurring right now that's being driven by the Chinese Communist Party. On February 13th, Admiral Samuel Paparo briefed a defense forum in Honolulu where he described the escalating operations around Taiwan as not exercises, but rather rehearsals for the forced reunification of Taiwan to the mainland. Furthermore, he said that these exercises are so extensive that they could be used now as a fig leaf to cover what will just quickly turn into an invasion or blockade. Rear Admiral Mike Studeman recently stated that he believes the risk of conflict over Taiwan is about 60% this decade, so by 2030. I think that when you take that risk of conflict, what State Armor does is we look at what does that mean here in the United States? And so if China were planning to launch a conflict that we're hearing from federal leaders and military leaders might be coming, we would expect China to be pre-positioning assets across the United States to disrupt our military here and our critical infrastructure here. And they're doing exactly that. We could speak in detail of examples in Texas, North Dakota, and Indiana, where land purchases were really a cover for PLA or CCP affiliated individuals to get near critical military installations in those states. So keeping, as this proposal does, keeping them off that land, making sure that they're not securing pre-positioning locations is critical to protecting military assets across the homeland. I'll go to the issue of drones, which actually could play a role in any sabotage efforts that could occur in the event of a conflict. There's a wide variety of warnings from the Federal Cybersecurity Agency, from the FBI, about drones from the People's Republic of China. The guidance from CISA, that's the Cybersecurity Agency, and the FBI highlights the potential for these drones to expose sensitive American national security information, that through firmware and patching updates that they could be pulling data from these drones. Some, intelligence leaders on the American side have estimated that they've mapped most of the topography of the United States through this access and that they continually update it. The former senior director of cybersecurity for the National Security Council, Joshua Steinman, recently said on a podcast that you have to be crazy to believe that the PLA cannot march into the offices of DJI, the primary drone company, and just ask them for all data that they've picked up in the United States. That's because all Chinese companies are legally required to be dual use. That means they have a military function and a civilian function. And the drones, the
1
DJI
minute
is
remaining.
really one of their clear examples of success in dominating a military technology and forcing their technology into the United States, making us dependent upon it so that they have espionage and sabotage opportunities. Last, I'll speak to the prohibition on tax credits for foreign adversary companies. I think that this is just right in line with what Kansas did last year by divesting pensions from the People's Republic of China. I think about $600 million was taken out from Kansas pensions that were in China. We simply shouldn't be financing foreign adversaries, particularly their military buildup and human rights abuses. And so denying them access to state tax credits is just in line with what Kansas did last year in leading on divesting pensions from China. Thank you for the opportunity. Happy to take any questions.
Great, that was 4 minutes, so thank you very much for helping us out with that. Do we have Jacqueline Deal on WebEx? She's not yet there, so okay. We'll next invite Lee Levy II from American Global Strategies. Please introduce yourself and welcome to committee.
Good morning. Thank you, Chair Warren, Vice Chair Titus, Ranking Member Corson, and the members of the committee for letting me spend some time with you today. I come to this hearing with considerable experience in the national security and economic security space. I'm a retired Air Force General Officer, having spent 34 years in Air Force joint and multinational roles to include responsibility for the industrial base for the Air Force, large parts of NASA, the U.S. Navy, and numerous foreign military sales countries. After service, amongst other things, I spent 3 years on NASA's board, worked with a number of federally funded R&D centers, think tanks, and advisored private equity firms, numerous space firms, and served as an independent director for several public and privately held companies in the national security space. I'm lucky enough to have a master's in international relations, a master's in national security and strategic studies, and a doctorate from Vanderbilt in organizational change and leadership. For better or for worse, during my tenure in the Air Force, I had a front row seat to the efforts of that the CCP is undertaking in the United States and around the world to subvert governments and societies and to seek to gain economic, political, and military advantage. Since I left the military, the threat posed by the CCP in the US has grown. It's no longer a distant military and cyber threat in the Indo-Pacific, as Admiral Paparo might have opined, but is now one that involves substantial personal and economic risks to American citizens, to include the citizens of Kansas. As Americans think about their response to the CCP's predations, it's essential to understand the reality that no company or entity in China is truly private in the sense that Americans would understand it. Beijing's top-down control over Chinese companies and commercial enterprises, regardless of whether the state officially owns a stake in the company or not, is just a fact. As mentioned, it's enshrined in China's legal system. It has numerous national security laws that require all business and individuals to use their resources to support the CCP if called upon to do so. In essence, if a Chinese citizen or company fails to assist the CCP in, say, obtaining intellectual property from a US-owned firm or US institution of higher learning, they are actually violating the law. Given the implications of this top-down business environment, we must recognize that when it comes to Chinese-owned business, all roads lead to Beijing. One critical vulnerability that strikes at the heart of hardworking everyday Americans is the pension rules. And you just heard some of this discussion from Mr. Lucci just a few minutes ago, so I won't repeat that, but Kansas's leadership here is essential. They've also extended their reach into American society, such that it targets dissidents and others that are opposed to the regime. Across the country, states are now having to deal with the reality of Chinese agents coercing individuals into silence while federal government struggles to catch up. Most states don't have statutes in the law to cover this particular malign activity in the criminal code, and instead rely upon other more general statutes. It's only fitting that states enact laws and attach punishments that reflect the brazenness of this behavior. Another example of China's malign efforts is of grave significance to Kansas farmers. As mentioned, we've seen an uptick in agricultural land purchases in the U.S. by Chinese-linked entities. Already hundreds of thousands of acres of American farmland have been bought up by Chinese entities through a maze of shell companies. Lastly, I would like to talk just a bit about technological competition, where our states and localities are exposed to malign influences, such as 5G telecommunications, where the CCP has readily bought into American telecom systems. And of course, you heard us talk a little bit about drones, and it's clear that we need a national strategy and response to sufficiently protect American citizens and to keep our economy secure. I'm grateful for the chance to speak with you today, and I truly look forward to taking any of the questions that you might have, and I'll just pause there. Thank you.
Thank you, and appreciate you helping us out with our time limit. And committee and conferees, if we can hold all our questions till all the conferees have had an opportunity to speak, that would be great. So next, we will also check in, is Jacqueline Deal on WebEx? Not on WebEx yet. Then we'll invite Aaron Popelka, VP of Legal and Governmental Affairs, Kansas Livestock Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Aaron Popelka with the Kansas Livestock Association. And we appreciate the opportunity to share. We're testifying neutral and share our concerns with the bill and where our association's at. So from our perspective, we don't oppose the bill primarily due to the grandfather clause that allows existing businesses to maintain operations. Our concern is with the future and our concerns with the meat processing industry, and I know a representative from Smithfield's here will testify after me, I believe. But our concern is that we don't disrupt those processes, because as we saw in COVID, if we disrupt the supply chain, that ultimately results in lower prices to the producers. As our members and board looks at this issue, we view it really as a federal issue. We think it's something that needs to be addressed, but really the federal government is in the best position to handle this. Our policy is essentially a free market policy, but our board said, you know, there are times under national security where we ought to look at doing things. And so again, getting back to the national government, The things that have been done over the last year have kind of strengthened this process. I know Congress last year added the Secretary of Ag to the Committee on Foreign Investment in the United States. That's a committee that reviews foreign transactions on critical infrastructure. The Biden administration added rules to increase penalties and compliance under CFIUS's purview. And then President Trump, in the last month, issued a security memorandum directing CFIUS to look at certain things. So we think the federal government is moving in the right direction. We also realize there may be a role here for the states. And to that end, I've listed in my testimony a few things that we think the state ought to consider. One, limit it to foreign adversaries, which the bill has done. Look at only actual threats and not limit it to agricultural land. Again, the bill has done that. And some limited exceptions for things that happen that may be like inheritance, foreclosures, things that allow free exchange of title. But the other thing I think that we have a concern about is, again, not disrupting existing businesses that have proven not to be a security threat. I know the rep from Smithfield's here, and he can get into their structure a little bit, but in 2013, CFIUS reviewed them and determined they were not a threat. And so from our perspective, I've attached to our testimony last year, this bill is very similar to last year, with the exception of the grandfather clause. And there's a piece in there that said that if a company has received review by CFIUS and been cleared, then that company could continue to operate, invest in the state, and continue their operations. I've attached that amendment to my testimony for your review consideration as the Senate moves into conference. And we understand that in conversation with the House, there may be some concern about CFIUS, but we think that starting with this as a base, we may be able to come up with some language to take care of our concern to make sure meat processing continues. So thank you, Madam Chair. Happy to stand for questions at the appropriate time.
All right, well, you had another minute if you needed it, but
I will be brief. I know you're short on time.
okay, great, thank you, appreciate that. We do have Jacqueline Deal on WebEx, so we'll circle back and invite Jacqueline Deal then. Please introduce yourself. Welcome to committee, and we're limiting everybody to 4 minutes, so I will briefly interrupt and let you know when there's 1 minute remaining so you can wrap up your comments and your thoughts. Thank you.
Thank you very much, and I apologize for the delay. I'm in transit this morning, unfortunately, but I really appreciate the opportunity to be with you, at least virtually. My name is Jackie Deal. I'm based in Washington, D.C., and I'm an advisory board member with State Armor. I have spent my career, about 2 decades, researching the Chinese Communist Party and its history and its military. Here in Washington, D.C., people generally acknowledge the fact that Kansans are best positioned to make decisions for Kansas. That's how our federal system of government works. But the Chinese Communist Party doesn't share this perspective. Rather, it believes that the Chinese Communist Party should make decisions not only for all of China and the Chinese people, but even for people in other countries. It doesn't believe in representative government or self-government. It's rather trying to extend its techno or digital authoritarianism or totalitarianism, not just within China, but even to other countries, including the United States, into the United States, to states like Kansas. Unfortunately, the objective of the Chinese Communist Party is to reach inside other countries like the United States to manipulate our perceptions and our policies in directions that are favorable to the Chinese Communist Party itself. They believe that through this strategy, over time, they'll get access to our resources and intelligence from the United States, from individual states, and this will help prepare for war if necessary so that the Chinese Communist Party can achieve its objectives. So to do that, they take steps such as purchasing land in our country, which gives party-linked affiliates access to and intelligence on U.S. military facilities when the land is proximate to those, obviously. They allow Chinese Communist Party linked companies or subsidized companies to sell drones in the United States, and then they claim access to the data from the feeds from those drones so that they can get information from real-time coverage on the ground or in the air in the United States. And they get access to state government and federal government funding in the United States for organizations that pitch themselves as independent or grassroots organic, but are actually linked to the Chinese Communist Party. I believe that Kansas has an opportunity to protect Kansans from this set of threats with SB 9. I put in my written testimony some quotes from Chinese Communist Party elites and scholars laying out their strategy for going deep into the United States. So I won't reread those quotes, but they're submitted in my written testimony. But I think the important idea is that they have a strategy. They've had it for at least 10 years now of, quote, going deep into the United States to influence decision-making and politics, again, through these land purchases, through digital or high-tech companies that get access to data, and through what appear to be grassroots organizations, but are actually linked to the party. And they have a system for connecting the dots between these entities and the party itself in Beijing called military civil fusion, which the General Secretary of the Communist Party, Xi Jinping, has kind of spearheaded. So over the last 15 years since he's been in power, he's worked to ensure that the party has cells in even nominally private companies, and he has formalized the party's claim to information that's in the hands of Chinese individuals or companies, even if they're supposed to be private or commercial. He
1
says we
minute
get access
remaining.
to that data. So the point is they have a strategy, they're executing it. Unfortunately, it takes them into US states like Kansas. And I think this bill is an opportunity for people in Kansas to protect themselves. If we want the Chinese people ever to kind of have the rights and privileges that we have, we should impose costs on the CCP for trying to subvert our system and put up barriers like the ones in this bill so that we actually preserve the alternative system that we're championing in the United States. Thanks very much, and I'm happy to take any questions, and I apologize again for the delay.
Thank you, and I'm glad we were able to connect this morning and appreciate your testimony. Up next, we will hear from Stephen Kuba, Government Relations Manager, Smithfield Foods. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Madam Chair, members of the committee, thank you for the opportunity to speak with you all today. My name is Stephen Kuba. I'm the Government Relations Manager for Smithfield Foods. And unfortunately, we are opposed to the bill as currently written. So a little bit about our company, as Aaron alluded to. Smithfield Foods is an American food company. We employ 34,000 people across the United States, across 23 states and 39 facilities. In Kansas, we employ 1,000 people in 2 facilities, one in Wichita and one in Junction City. We also contract with 1,900 contract growers across the United States and own and manage 400 company farms. So that's a little bit about our general footprint. I know the question of our ownership structure comes up a lot, so I will tell you, Smithfield Foods is a publicly traded company on the NASDAQ stock exchange. So that's what makes us a little different than I think about some of the other companies that you've heard about, right? Our majority investor, and as Aaron alluded to, our transaction from our majority investor from our acquisition in 2013 was reviewed by CFIUS with no mitigation measures. So it was completely approved. Our majority investor, WH Group, is also a publicly traded company. They are based in Hong Kong, but they're publicly traded and their shares are listed on the Hong Kong Exchange. So once again, they don't undertake activities on behalf of the Chinese Communist Party, and they are not a Chinese state-owned enterprise. And once again, I think that's what makes us a little bit different. Now, the proposed bill's underlying text has gone through a lot of changes over the last 2 years, and I will say I appreciate the House Majority Leader giving us time to address our concerns, and take some time with this committee, with the informational session, with the conference committee to make some changes. While those changes may be forthcoming, we still have concerns, and so once again, we have to stay opposed to the bill as written. I want to reiterate that Smithfield Foods is an American foods company. Over the last 10 years since being acquired by WH Group, WH has made billions of dollars of investment in the U.S. production platform and hundreds of millions of dollars of investment in the communities where we operate. And that's what I really want to hone in. We respectfully request an amendment to this legislation that will allow Smithfield Foods to continue to invest in Kansas, our communities in the great state of Kansas, and our company. We've worked with the Kansas Livestock Association to submit several amendment options. We're grateful for the chance to discuss any of those with you. While we're opposed to the legislation as currently written, we look forward to continued conversations. I'm happy to take any questions, once again, thank you for the opportunity.
Thank you. Is there anyone else in the committee meeting room or on WebEx wishing to be a conferee in our informational briefing on Senate Bill 9? Not seeing any, then committee, we can open it up for any questions. And I do have a question, maybe this is for the reviser. For our new committee members, this has been a bill that has been around the last couple of sessions, and you heard some testimony about how it's the same but a little bit different. So I didn't know if the reviser could, if there were any questions about that, please raise those. I think last session, the bill made it out of one chamber, but didn't advance, which is why we're considering it again this session. So with that, any questions? Okay, then everyone clearly understands what the bill does, but I want to thank our conferees for appearing today and for the great explanation. And with that, then, we will close the informational briefing on Senate Bill 9, and we're going to open the informational briefing regarding government agencies, public utilities, and other entities when exercising the power of eminent domain for recreational trails and park and recreational facilities. And with that, a statement from the reviser.
Thank you, Madam Chair. Madam Chair asked me to give you all kind of a brief overview of eminent domain in Kansas and kind of the power of eminent domain. To assist with that, you have two documents from us. Thanks to two other attorneys in our office who are very well versed on this topic. You have a memo from us that kind of talks about the overview of eminent domain authority. You also have a chapter from a book by an attorney in our office, Mike Heim, who I'm sure many of you know. I included his chapter on eminent domain, so you can look through that at your leisure. Essentially, the state possesses an inherent sovereign power of eminent domain to take private property for public use. The legislature may delegate the state's power of eminent domain to public and private entities. And on page 1 of my memo, you can see the footnotes to statutory references where you all have done that many times for various purposes and to various different agencies. The Fifth Amendment of the United States Constitution and Article 12, Section 4 of the Kansas State Constitution prohibit the taking of private property without just compensation. KSA 26-513, which is in the Eminent Domain Procedure Act, also prohibits taking of private property without just compensation, and it requires that the measure of compensation be based on the fair market value. Generally speaking, the fair market value of that property would be the value that the property would garner in an open competitive market. To determine fair market value in an eminent domain proceeding, the presiding judge appoints 3 disinterested appraisers, and those appraisers take an oath to faithfully discharge their duties. The appraisers are also required to refrain from any ex parte communications with the parties, and they have to disclose any written materials that's provided to one party or to another party. To establish the value of property, the appraisers examine the land and hold a public hearing. They receive oral and written testimony from interested parties, including the landowner. And then we have a state statute that provides a list of factors that shall be considered when determining the amount of compensation that should be provided to a landowner. You can see that on page 3 of my memo there. We do have an Eminent Domain Procedure Act, like I referenced earlier. You can find that at KSA 26501 at SEEK. Any proceedings for eminent domain have to be conducted pursuant to that act, and the act establishes the procedural requirements for any of those entities that you have delegated that authority to lawfully exercise their that eminent domain authority. The process begins when an entity files a petition for the taking in district court where the property is located, and then all parties named in the petition have to be notified of the proceedings. The eminent domain proceedings will commence if the court finds that the entity possesses the lawful power of eminent domain and that the taking is necessary for the corporate purpose of the entity. And that kind of brings us to the public use requirement. Eminent domain can only be used for taking private property for what's considered a public use. And for those of you who are interested, kind of the leading Supreme Court case on this issue would be, I think it's Kelo versus City of New London. At 545 US 469 if you're interested in reading that. But traditional concepts of public use relate to the provision of basic and essential governmental services such as roads, sewers, water facilities, utilities, and other public functions. And over time, the court has expanded and broadened that concept of a public use beyond that traditional concept to expand it to things using a public benefit analysis, which is outlined in that case law. So that's kind of a general, very general overview, but I'm happy to take any questions that I probably won't know the answer to, but I can try. Anything that the committee has.
Thank you, appreciate that. And the reason you were getting into some details about what the procedure would look like was there is a bill that addresses this that's in committee, but it's not a hearing on the bill. It's just we're kind of introducing the concept and maybe something we want to be taking a look at a future time. And with the Kelo decision, I think is it a little bit controversial or kind of being looked at again? Or I was reading something about it the other day, so maybe not. But are there questions for the revisor? Not seeing any, then thank you very much. And we're going to go ahead and limit testimony still to 4 minutes for each person. And we will first hear from Conferee Brett Fairchild, Kansas House of Representatives, 113th District. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. I'm not going to spend very long on this because I have to get to the House floor for some votes, but I just wanted to explain the reason why I introduced this bill. A lot of my constituents have some concerns about eminent domain, particularly as it relates to, the transmission lines that are going across the state. They have concerns about the Grain Belt Express transmission line, and so I just wanted to try to be able to respond to the concerns that people have about that and about eminent domain in general. And there was a group that I met with in Great Bend, a private property rights group that met once a week, and they were wanting somebody to introduce a bill on eminent domain to try to reform and limit eminent domain, and I told them that I would do that. I would say that this bill doesn't go as far as they would want it to go because this group basically just wants to ban all eminent domain along the Grain Belt Express, along wind energy transmission lines, and this bill doesn't do that. It doesn't specifically mention wind energy transmission lines or the Grain Belt Express. This is more just a bill to try to limit eminent domain in general and to make it more rare, to make it harder for the government to use eminent domain. And this is a bill that was based off of a bill that was introduced in Ohio, but it doesn't go quite as far as the Ohio bill. The revisor said that some parts of it weren't applicable to Kansas state law. I do want to mention, I wrote something down wrong in my testimony on the third paragraph. It says, first, the bill completely ends eminent domain for economic development reasons. In 2006, an eminent domain reform bill was passed by the legislature and signed into law. This is a good law, but it provided an exception for the legislature to authorize eminent domain for recreational purposes to do so. I meant to write, instead of recreational purposes, I meant to write economic development purposes because that was the 2006 law that the legislature passed to basically end eminent domain for economic development purposes, but then it left an exception for the legislature to authorize that if they expressly authorized it through legislation. And so this bill would end that exception and make it to where the legislature couldn't authorize eminent domain for economic development reasons. And so basically this bill, I don't really have time to get into all the details, but it's just trying to limit eminent domain as much as possible and to respond to the concerns that people have. But a lot of these people, like the Great Bend group, they would like to go much further, but I basically told them that I didn't want to go quite as far as they would want to go. That, this group supports this bill, but they would want to go much further and actually try to end eminent domain along the transmission lines.
All right, thank you very much for your testimony and for, I know you're delayed getting to the House floor, but thank you for appearing today. Appreciate it. Any questions for the representative before he leaves? No? Okay, well, great. Well, thank you again. Next, we will hear from Dave Peck on behalf of Evergy, Kansas Electric Cooperatives, Kansas Municipal Utilities, Liberty Utilities, and NextEra. Please introduce yourself and welcome to committee.
Morning, my name is Dave Peck. I am the Director of Project Management in the Transmission and Substation Construction Division at Evergy. I appear before you today to represent not only Evergy, but Kansas Municipal Utilities, Liberty Utilities, and NextEra Energy Transmission. So I just want to thank you for inviting me here so I can share some of our land acquisition activities that go along with the utility business in Kansas. So just to give you some background on myself, I've been working in the power industry for 37 years. I've worked at Evergy for about 16 of those years. My job at Evergy is to lead a team of 9 project managers, and we focus on constructing either brand new transmission lines and substations or rebuilding existing transmission lines and substations. I've been involved just myself personally in about rebuilding about 330 miles of transmission lines in Kansas and 10 substation projects. Almost every one of these projects involves some type of land acquisition. An electric utility's approach to easement acquisition is to only use eminent domain as a last resort. These people that we ask to put facilities on their property are our neighbors, our customers. They pay electric bills to Evergy and the other utilities in Kansas. We want to develop a good relationship with them as we start the project and continue that all the way through to the end. Just as a matter of point, the electric utility industry is a little bit unique in that we don't ask, we're not purchasing property from them. We ask for easement rights. That's mostly to put overhead transmission lines and just set aside the use of that property for the transmission line. The issue of condemnation has brought more attention to the legislatures over the past few years, and us in the utility industry, we hear your concerns. We're working hard to try to make changes to our processes and to communicate more with landowners. I also want to point out that sometimes an eminent domain is used when we don't have a disagreement with the landowner. It's a simple matter of we can't get a clean title to a piece of property. I'll give you an example that happened on a project that I was on in Manhattan. A father and son were working together side by side farming this land for a long time. The father passed away. The son didn't go through the probate process. So when we went to get the easement signed, he didn't have the legal authority to sign that easement. So in that case, we agreed with the landowner we would go through the condemnation process. Even though we agreed on the price, we went through the process. We gave the money for the easement to the court clerk, and then when he got finished with his probate, then the court awarded him the money. And that allowed us to proceed with our project while that was happening. So those come up quite often when we do this work. Also, the Kansas Corporation Commission has established some principles and priorities on their side in the Line Siting Act. So in the state of Kansas, if you're going to build a power line to a certain voltage and length, you have to get a siting permit from the KCC. And they updated that process to basically put more standards and clarity on how that has to happen in Kansas. So that'll help, we think, going forward. So that ends my comments for the group. I'll just give you a little bit of background from an Evergy perspective until my time runs out. So some firsthand experience, I can tell you guys that when we get a project and we're going to build a transmission line, acquiring easements is the hardest thing that we do. It takes a lot of courage to stand in front of a group of landowners and ask them to put this piece of infrastructure on their property. It's not something that we take lightly. It's not something that we like to do, But this is critical infrastructure. It's needed to support everything that we do. Just look at the amount of energy that we're using in this room. So we do it because we can see that it helps the state and it helps the community, it helps our region too. About 90%, when we get out a transmission line at Evergy, we set like a goal. We want to acquire about 90% of the property just through negotiation. We usually hit that goal. I would say on average, a rough average is about 5% of the time we would have to take somebody to condemnation. And that includes the cases when we don't have a clear title. So this is not the norm. We don't use eminent domain irrationally. We have to get, at Evergy, we have to get executive approval to file a condemnation case to make sure everybody's informed. So it's something we take very seriously, and we don't use it very often. So the majority of the time, we do find a way to work with our neighbors and put these transmission lines in, and we appreciate them, because the vast majority of them will work with us as we go through the process. So thank you for your time. That's about all I have to say. I'm ready to answer any questions.
That's great. Let's go ahead and have all the conferees, if you have time to wait till for questions at the end.
Sure.
Great, thank you, appreciate it. Next, we will hear from Kimberly Jenker-Swati, Public Policy Director, Kansas Power Alliance. Please introduce yourself and welcome to committee.
Good morning, Madam Chairman and members of the committee. My name is Kimberly Jenker-Swati, and I do appreciate the opportunity to appear before you this morning to discuss electric transmission lines. This is one of my favorite spaces to talk about. So, I do wear two hats, the Advanced Power Alliance and Kansas Municipal Utilities. So Mr. Peck did a wonderful job talking about KMU's perspective as it relates to transmission line construction. But from the Advanced Power Alliance standpoint, we are the owners and operators of wind and solar, battery storage, and hydrogen. But we're also the owners and operators of our nation's most complex and greatest engineering feat, which is the electrical transmission grid. Two of our member companies are in the transmission space. They're working with local partners to facilitate system upgrades and construct new lines through the Southwest Power Pool process. I do just want to make several key points. Representative Fairchild talked about wind energy transmission lines, and in the state of Kansas, wind and solar and any of their appurtenances, which includes transmission lines, do not have the right of eminent domain. So if you are going to build a wind farm or a solar facility in the state of Kansas, and any what we call a generator lead line associated with those projects, there is no right of eminent domain. Everything has to be done via private contract between a willing landowner and the company. So I do just want to make that very clear. In the two instances where two APA member companies have gone through the very rigorous process of becoming an electric transmission owner in the state of Kansas, or a utility in the state of Kansas, we have a project in southeast Kansas, and then of course the developer of the Grain Belt Express transmission line. So in your testimony, I've included several slides that was part of a presentation that the Grain Belt Express executive team provided to the Kansas Legislature in a joint committee between House Energy and Utilities and House Water, and then in Senate Utilities. We would be more than happy to come back. I'd be more than happy to arrange for them to come and provide the same information to you all. But I think the key point here is that the Grain Belt Express transmission line has more than 1,000 different landowners associated along the route, and roughly 99% of the land has been acquired via private transaction between a willing landowner and the company. And as Mr. Peck described, there are some instances where the eminent domain process was used, and that was largely just to clean up title, as Mr. Peck previously referenced. The data in here talks about the payments that go to, well, certainly the communities and whatnot, but then also how the transmission line really tries to minimize the impact to the landowners themselves, and it discusses the right-of-way trying to think if there's any other key information in here, knowing that our time is limited. I also would draw your attention to the slide here about the regulatory process that exists in Kansas for becoming a utility in the state, which does afford the right of eminent domain, but again, underscoring and stressing that the right of eminent domain is used on a very limited basis at all times. The transmission siting docket that the Kansas Corporation Commission did just conclude, they issued an additional guidance there, and it talks about general guidelines for transmission siting criteria and priorities. And a lot of that information was derived from Grainbelt Express's landowner protocols that they put in place and a code of conduct that have actually been I don't want to say endorsed, but certainly appreciated by the Kansas Farm Bureau. So I'm more than happy to answer any additional questions on the right of eminent domain, the very rare use of it in the state of Kansas, and certainly on behalf of the APA member companies. So with that, I'm happy to answer any questions.
Thank you. Appreciate it. Is there anyone else in the committee meeting room or on WebEx wishing to be a conferee in our informational briefing? Not seeing any. Then committee, before we open it up for any questions, I do want to note that at the back of your informational briefing folder at your desk, there is a copy of Senate Bill 262, which was kind of led to this informational briefing and the written testimony of our conferees. Do want to also direct your attention to, you have written conferee testimony from Tammy Hammond, CEO and founder, Rosewood Services, Inc. And with that then, are there any questions? Senator Haley.
Very briefly, thank you, ma'am. I appreciate that we have this and this informational. I have a great interest in this, in the takings and how they're allocated. Could someone share with me, I don't know if it's probably going to be Kimberly Jinkursvati or Dave Peck. One of the concerns we had in the takings was the use of the property for large poles. In other words, the siting or the how sometimes indiscriminately the need to have power poles and they're being taken was disadvantaged some of the property owners, especially in urban environments. And I was wondering, how did we reconcile the takings through eminent domain, or has that been reconciled to take into account the valuations of property, either for that purpose or others, because of the strict needs use that we have for utilities? If anyone does recall that, I'm just wondering what we said about that. It was a large issue a few years ago, and it did emanate from our discussion of eminent domain.
Please go ahead and reintroduce yourself.
Hi, this is Dave Peck with Evergy again. I want to be clear, I wasn't on that project, so I know a little bit about it, and I'll be able to share something, but I might not have all the answers that you're asking. But I think you're talking about the line in Wichita.
Yes.
Yeah. And so I think, well, I can tell you for sure that Evergy learned a lot from that whole process, and we've taken those changes and applied them to transmission lines, especially going through urban areas like that. So the disconnect happened when you have engineers in the office here in Topeka, and they're trying to look at physical things, wind loads, things like that, and make the most optimum use of a transmission structure, if that makes sense. So the bigger you make it, the stronger it is. So they optimized their design and sent it out the door, and not realizing the impact to the neighborhood. So you can take that same structure, make it smaller, and increase the metal thickness and get the same result. So that's what we're doing, especially in those urban areas, is making sure that we aren't oversizing anything. And we look at the area where the transmission line is today, and if we can, going into it, we try to make the new line about the same size or close to as the old line. One of the other factors that came in for that specific project is the use of what we call guy wires. So a pole might have cables, you'll see them around, and basically it's tying down that corner structure, and it's using that cable as a brace to hold it vertical. Well, we don't like to use the cable saves, you know, the down guys, because people have to mow around them. But when you take that support out, now the foundation has to get bigger and the pole has to get bigger. So it's a trade-off. So we can make the pole pretty thin if we guy it down. And those are some of the trade-offs that we're looking at to address those concerns.
Thank you, Mr. Peck. I appreciate that. And thank you, Madam Chair. I do appreciate the review also that we've been given for eminent domain from our team, from our staff. I'd be curious to know if we are now incorporating, during these takings of property, that we do incorporate some consideration of the effect it will have on the land value or the visual land value, especially in the placement of the needed the poles and the guide wires. Reading through this very briefly, it's pretty comprehensive, but it doesn't really speak to the need for that taking to incorporate the value of the property specifically that it surrounds. And I don't know if that's something we might visit at some point subsequent. I do appreciate your indulgence. Thank you, Madam Chair.
Thank you. And I do have a question, but is your question, Senator, the impact of surrounding property to the property that's being condemned, or the value of the remaining property of the landowner that it's a partial taking?
It could be either or both.
Okay.
There's been some discussion in another of what impact those turbines would have, wind turbines would have for the aesthetic value of certain property. That's another issue for another time. But so to your question, it could be that. My specific concern was for an issue raised, former member of the legislature, the late Gail Finney, Representative Finney from Wichita, regarding large, big poles that were placed in the yards of certain neighborhoods needed for energy, and how they were being taken through eminent domain to meet the public need of the transmission lines, and how it disaffected the valuation of the immediate property owners and perhaps those of the surrounding property owners as well.
The question for the revisor, if you wanted to comment on, I wouldn't think that you're not taking into account adjacent or other landowners other than those who are part of the condemnation proceeding. But if you want to speak to that.
Sure, thank you, Madam Chair. I think that would come into the just compensation analysis of, the fair market value of what you're taking, if that's a partial taking for something like a utility pole.
I think there is case law in Kansas that if you can prove an impact to your particular property, that you could make a case for seeking just compensation, but something to do a little bit more research on. But thank you. And my question, yes, Ms. Fadi, did you have something you wanted to add? Please reintroduce yourself.
Kimberly Ginter-Swati on behalf of the Advanced Power Alliance, and just some additional follow-on information to Senator Haley's question, if that's okay. So Senator Haley, you had asked about particularly transmission development in more urban areas. And so the Kansas Legislature did address that particular issue at the spurring of the former Representative Gail Finney. And so that process was the process to develop transmission lines in more urban areas in a population of above 100,000, or maybe it's more, is a bit different than developing transmission out in more rural areas. And that was as a result of Representative Finney's efforts and work with the utilities. And then I also want to make sure that everyone understands that when an eminent domain case begins, landowners are always compensated through the process. And in the case of building transmission, it's always a partial taking. So you can see through my testimony a visualization of what a high voltage transmission tower might look like. This is a much larger tower because the Grain Belt Express is operating at higher voltage, but you also see the higher steel monopoles as you're driving down Fairlawn or through Topeka or on 87th Street in Johnson County, or certainly around Manhattan, and those are the tall monopoles. Again, a partial taking, and so in the case of the Grain Belt Express, it has a 150-foot right-of-way, which is the sole footprint, and the landowner is completely compensated for that footprint and the partial taking. So it's not as if an entire parcel of ground is taken, and in most instances, the landowner is able to use that ground right up to the base of the transmission tower and receive compensation for it. And in my testimony, I did provide a listing of the compensation schedules generally. I hope that helps.
And when you say case, do you mean you're anticipating this is, we're dealing with this landowner and our utility, and it doesn't necessarily mean the lawsuit has been filed yet, because you're trying to work it out short of taking it to court?
Absolutely, utilities, and certainly in the case of Grain Belt Express, but I think, you know, being in the utility space and having developed 900 miles of high voltage transmission, utilities always want to work with the landowners first and foremost, unequivocally. That is, trying to find mutual agreement is absolutely the path that landowners want to go first. There are instances when eminent domain is used when they can't get clear title, if there's multiple landowners, or in the case with Mr. Peck, as he described the father-son situation. But very rarely is eminent domain actually used where you're going to a proceeding. And I do have some data points and did share those data points with this committee following the hearing that was held at the beginning of session on eminent domain. And this specifically related to, in the case of Grain Belt Express, and I think this is a nice demonstration that, let's see, just one second. In the case of Grain Belt Express, we're dealing with more than 1,000 individual landowners across this route, and 97.5% of easements were obtained via voluntary agreement or settlement, and only 17 out of 1,005 were acquired through a contested appraiser's hearing. So I think that's a solid demonstration of how utilities really try to work with the landowners first and foremost.
And in that case, if it goes to court, the issue is usually, is it not, about the just compensation piece, and then that just compensation piece would be determined by a jury.
Of the three disinterested parties, as the revisor spoke, yes.
Right, okay,
Yep.
Great, thank you.
Which
Any
is all
other
spelled out in
questions for our conferees? Yes, Senator Bowser.
Thank you, Madam Chair. Thank you, Madam Chair, for allowing these informational briefings today, but very informative and helpful. I have 5 counties that the Grain Belt Express goes through. This was really a hot campaign topic. And I will tell you that most of the concerns, again, this would go back about a year ago. In the district, we heard about this 5-mile wide NIETC eminent domain, and that really alarmed my constituents. The good news is that, and I just talked to Congressman Mann last night about it, and I see it again confirmed here on your presentation, that NIETC proposed swath has been dropped, which is a very positive thing. It eased a lot of concerns of my constituents. I think generally speaking, most folks, again, are okay with the Grain Belt Express, and we're delighted that this crazy 5-mile wide NIETC thing has been dropped. So thank you for your testimony today. Again, thank Madam Chair for these informational briefings.
Thank you.
Thank you. And we do have a question from Senator Bowers.
Thank you, Madam Chair. And I'm going to piggyback on what Senator Bowser just said. And I have 7 of those 14 counties, Senator Bowser, so I beat you. But I do want to just mention that we were very engaged with the company and with our constituents and with Farm Bureau who are in the room, that the misinformation about this project was massive, and how Farm Bureau stepped up and had hearings or had meetings to inform the community as what was going on. And to complicate the matters, it was the Department of Energy project and not a vote that our Congress people could make. So that was something that they couldn't even control. And what we learned from this of the a code of when you go in someone's home, what should that look like? Or how do we handle the information that isn't correct? We did learn a lot about citing. And what we do as local communities, do we have a county resolution saying they're against eminent domain? What can we do at the local level? So we did learn a lot through this process. It was very painful for some of these meetings that we did as well. But we did learn some things from this that we can bring back good ideas to put into law. So codify what does a good conduct law look like, and what KCC is working on with citing. Those are important things to us rural legislators. So thank you for being there when we had questions, and thank you to Farm Bureau for stepping up and doing that for us. Thank you.
Thank you. Committee, other questions? Not seeing any, then thank you for your testimony. I appreciate everyone being here. And we will then close the informational briefing on the government agencies, utilities, and exercising power of eminent domain. We didn't really talk about recreational trails and park and recreational facilities, but we had a lot of information provided. So thank you, appreciate that. Next committee, it's our last day to meet as a committee. So there was a bill that I wanted to bring up for possible final action, and that would be Senate Bill 242. And we heard that some time ago. We heard that March 3rd. March 3rd. So if we could get a brief summary from the reviser, that would be helpful.
Thank you, Madam Chair. Senate Bill 242 requires a political subdivision to hold an open meeting to discuss entering into a contingency fee contract for the provision of legal services. It also requires them to, after it's approved by the political subdivision, to submit such a contract to the Attorney General for approval or disapproval. And I can take any questions.
Thank you. Committee questions for the reviser? Not seeing any. Then I do have an amendment that I'd like to pass out, or ask the reviser to pass that out. But before we do, if you'll recall, this would require kind of a review. Well, go ahead. That'd be great. Thank you. It would be at a public meeting. You'd have to, the body that wishes to enter into a contingency fee contract, would have to disclose the reasons for pursuing the matter and the qualifications, experience, and competence of the attorney or law firm selected or considered for selection by the governing body. So you have the amendment in front of you, and I'm going to ask the reviser to please explain what it does.
Thank you, Madam Chair. So you'll see the first change there on page 1. You'll recall that there's a list of things that the political subdivision has to include in their notice of having the meeting. This just adds that that list can be included in the agenda for the meeting. With respect to the provision that Chairwoman Warren just spoke to, the qualifications, experience, and competence of the attorney, it's currently as proposed in the bill right there, it says that the attorney or the firm that's selected, and this would add or considered for selection by the political subdivision. Also, you'll recall that the political subdivision has to make certain findings on the record before they can enter into that contingency fee contract. One of them is that there's a substantial need for the legal services that are the subject of the contingency fee contract. And this would add to that finding that they have to find that it's in the best interest of the residents of the political subdivision to contract for those legal services, or that there's that substantial need. So it would be one or the other there. over on page 2, you'll recall that one of the reasons they can enter into that contract is that they don't have the funds necessary to pay on an hourly basis. And this is adding, or that they would pay substantially more for those legal services if they were provided on an hourly basis. Again, another addition to the agenda. You'll recall also that the Attorney General, once the contingency fee contract is submitted to them, they have 90 days to go through and either approve or disapprove of that contract. This is changing it to 45 days. It also requires the approval of the contract if the request involves a matter of purely local concern and does not implicate any statewide interest, then that approval has to happen promptly. The legal matter about the contract here, we're changing that to one or more questions of law or fact that's in common with either a lawsuit, a demand, or settlement, asserting or resolving claims that the state has either already addressed or is pursuing. So that would be one of the reasons that the AG would have to disapprove of that contract. The other one would be the legal matter involves claims or issues that are more appropriately within the scope of state enforcement, and the pursuit of the matter independently by the political subdivision could lead to inconsistent legal outcomes or undermine the state's unified position. You'll recall that if the Attorney General doesn't take action on the contract, then within that 90-day period, the contract shall be deemed approved. Again, we're changing that to 45 days, and there's an addition that if the Attorney General refuses to approve the contract, the Attorney General shall provide notice to the political subdivision in writing with a detailed explanation of the reason for refusing to approve that contract. It also allows the Attorney General, the bill as currently drafted allows the Attorney General to come into a lawsuit that involves a contingency fee contract that violates this section. They can come in and request that the suit be dismissed. This would say that they could still do that, come in and ask for it to be dismissed, or they could intervene and recover damages on behalf of the political subdivision. The current subsection D applies to any contingency fee contract that has entered into prior to July 1st of 2025, and this narrows that window. So it would just be that these provisions would apply to contracts entered into between July 1st of 2024 and July 1st of 2025. And it would also make the AG's review of those contracts discretionary instead of mandatory. We also add a definition of legal services. So you'll see there that legal services are services that are either performed by or under authority of a law firm or attorney, whether or not those services are performed by someone admitted to practice law, and services that constitute the practice of law in Kansas. And then we have some specific exemptions. Legal services does not include services performed by bond counsel, attorneys or other persons in the collection of debts, fees, fines, attorneys to recoup costs, including deductibles from at-fault parties' insurance companies, attorneys to assist with the sale of property, or court trustees. And then finally, there's an exception in there for the definition of political subdivision. It would not include a water utility as defined in KSA 1935-01. And I can take any questions.
Thank you for that. Committee, this is a pretty broad amendment. It was brought to us by the Office of Attorney General. So I guess, is there a second regarding the amendment? And then, or I guess we'll ask questions of the reviser first, since it's pretty detailed. And anyway, are there any questions for the reviser? I'm not seeing any. Is there a second to the motion? And then if there is, we'll open it up for discussion. Senator Reichman with the second. So with that then, any discussion? Yes, Senator Corson.
Thanks, Madam Chair. Given we've got exactly 10 minutes left, I believe, in our Judiciary Committee for this regular session at least, I'm going to stand in opposition to this because this essentially rewrites the entire bill, and we just haven't had a chance to really hear from proponents and opponents of the bill about what it would do and whether they are folks who testified as proponents would still be proponents with these changes, whether this helps bring on any of the opponents, whether it addresses any concerns. To me, this is not really a minor amendment or a technical amendment. This is really, at this kind of late hour, a wholesale rewriting of the entire bill. And given that I haven't had a chance to talk to any of the folks who testified either in favor or in opposition, I think the conservative approach is just to oppose this, and this may be something we can look at next session and get folks back with providing their input on these kinds of changes. But to me, this is just too substantial to make at this late hour. Thank you.
Thank you. Just a little clarification. My understanding, as it's been represented to me, is that the AG's office had conversations with the league on this, and that this would be something that those two entities have agreed to. If that helps with understanding the amendment and its position. So Senator Titus, if you had a question. Okay. Any other comment or discussion? So not seeing any, then again, this is a compromise between the AG's office and I think it was the League of Municipalities. So with that, then I would close and move the amendments. So you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The chair is in doubt, so can we have division? And with that then, so all those in favor signify by raising your hand. Okay, and all those opposed? Okay, by my count, the vote is 9-3. So the motion passes and we are back on the bill. So with that then, any other discussion or amendments? Yes, Senator Haley.
Thank you, Madam Chair. I don't know if I should support this now. I did like the underlying bill that we did have before, as was represented. I don't know what we've really done. I do accept your assertion that all parties have come together and that the amendment that you all just adopted is agreed to. If in fact that does bear out to be the case, which we'll have some time to do, should the bill pass out as amended, then I would change from my being concerned enough to be opposed now to supporting it when it comes to the floor.
Thank you for that comment. Does anyone want their vote recorded? I didn't ask, so okay, no one wants their vote recorded. With that then, any further discussion? Senator Bowser.
Thank you, Madam Chair. I support this bill, and if I had to say why I support it, it's transparency. This bill provides transparency, and I'm all in favor of transparency. Thank you, Madam Chair.
Thank you. Committee, other discussion? Not seeing any, then is there a motion on the bill? Committee, I do have one other amendment, and it is to open House Bill 228 for the purpose of taking out its contents and putting in the contents of Senate Bill 242 as amended. So that would be my motion Is there a second? And that's so it can go to conference, so the bill can help advance this session. Is there a second? Senator Klemp, any discussion? All right, I'll then not see any discussion. I'll close on the motion, and you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We are then on House Bill 228 as amended. Any discussion? Any motions? We're back on, I guess, Senate substitute for House Bill 228. Senator Titus. I'm sorry, 2228. Thank you.
Thank you, Madam Chair. I would move that the committee pass Senate substitute for House Bill 2028, recommended favorably.
I'm sorry, I think it's 2228.
2228.
Yes. Okay. Well, with that, is everyone clear, and is there a second? Senator Bowser with the second. Any discussion? Not seeing any. Then, Senator, did you want to close? Thank you. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. No. The motion appears to carry. The motion does carry. Does any senator wish his or her vote to be recorded? Not seeing any. Then thank you, committee, for your work there. And most importantly, we're going to close our regular work in our committee here for this particular session. We will be having a hearing that will be on the agenda shared tomorrow when we post that regarding the hearing regarding possible confirmation of the nominee for the Kansas Court of Appeals. We will be hearing that during conference committee week. So take a look at that, and that will be coming. So I want to thank everyone for their work this session, and for the senators who it was their first Judiciary Chair, our Judiciary session. Want to welcome you and thank you again for your hard work, and the returning members as well, and to our staff. Some were new, some were returning, but everyone did a fabulous job. So thank you, and thank you to all the conferees who have appeared in front of our committee, either live or via WebEx. And with that then, the meeting is adjourned.